The next case to come before the court is Nasser, Salem v. Faten, Hammouda. I hope I said that properly. If not, you can correct me when you counsel. Each of you will have up to 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal, and if you do plan to reserve time, please let me know, and I will keep track of the time. The arguments are being recorded, so please stay behind the podium, introduce yourself, keep your voices up. Please do not use the names of minors or children or victims during your arguments. You can refer to those folks where they may come in by initials or general terms. The judges have read your briefs, and we are ready to proceed when you are. So, counsel, I would just ask you, would you like to reserve time for rebuttal?
Yes, Your Honor. I would like to reserve 90 seconds of rebuttal time.
90 seconds. All right. You can make it hard on me. Very well. Then you may proceed when you are ready.
Thank you, Your Honor. May it please the court, Attorney Nicholas Klemenko on behalf of the appellant, Nasser Salem. Mr. Salem is requesting that the court find reversible error in the trial court's December 16, 2022 judgment entry that granted appellee $37,500 in attorney fees pursuant to Civil Rule 37A5 when only $3,250 was reasonably related to the Civil Rule 37 discovery dispute, as testified by appellee's own expert witness. However, even a granting of attorney fees in the amount of $3,250 is improper when reviewing the procedure and facts of the case and how the two motions to compel were granted at the trial level. On November 16, 2021, appellant submitted his response to appellee's discovery request. Just 2 days later, on November 18, 2021, appellee filed a motion to compel and request of attorney fees without factual support of the mandatory certification that a good faith attempt was made to obtain discovery without court action. A review of the November 18, 2021 motion filed by the appellee in the trial court indicates that there was a certification that defendant, by and through her counsel, has requested by electronic format that plaintiff comply with the discovery request. See the attached. No attachment was provided in the trial court level. There was no record of when the request was sent. There was no record of whether or not Nasser's previous counsel responded or even in fact had time to respond. The trial court granted this motion without facts in support of the mandatory certification and without providing appellant an opportunity to respond, as it granted the order to compel on the same day that the motion to compel was filed on November 18, 2021. Well, what would have been a reasonable amount of time to give to Mr. Salem to respond to appellee's motion to compel? Pursuant to Ohio Civil Rule 6C1, a party has up to 14 days to respond to a motion. Mr. Salem was not provided this amount of time. Further, the second motion to compel was filed on November 1st, 2022. This motion also failed to meet the requirements of Civil Rule 37A1. And again, Nasser was not given a reasonable amount of time to respond. And that order to compel was granted just 24 hours after the motion to compel was filed. The November 1st, 2022 motion to compel cited no efforts to obtain discovery without court action with Nasser's current counsel at the time, and instead relied on in-court cross-examination of the appellant on September 6, 2022 at a Civil Rule 60B motion as an effort to obtain discovery without court action. Why does the lack of compliance with Civil Rule 37A1 and its certification matter as it pertains to attorney fees. Because it dovetails into Civil Rule 37-5A, which the $37,500 was granted under in this case. That portion of the rule stating that the court shall not order attorney fees if the movement filed the motion before attempting in good faith to obtain discovery without court action. Appellee's own witness, expert witness, concluded that appellee did not document her good faith attempt to resolve the discovery dispute without court action in both motions, citing the transcript from November 9th, 2022, page 59 and page 66. Why does all this matter? The approval of appellee's motions to compel would promote the filing of motions to compel. The moment a party initiates an inquiry into discovery, and they would be able to receive an attorney fee award shortly or immediately thereafter, which would promote litigation for profit and deter alternative dispute resolutions. An abuse of discretion implies that the court's attitude to Mr. Salem was unreasonable or arbitrary. This can be...
Did the court make a finding that he had failed to comply with discovery after attempt by counsel to resolve the discovery issue? I understand you're saying there wasn't a affidavit yet. In the trial court's orders throughout this matter, were there finding that the defendant, or I guess the plaintiff's case, had not complied with the discovery request?
There may have been that language in the orders to compel that were presented to the court in connection with Ms. Hammouda's motions. But again, that goes to our argument that Mr. Salem was denied.
Well, I understand that part, but was there language in those orders, do you recall, saying that there were attempts made to resolve the discovery dispute?
I can't recall off the top of my head of that, Your Honor. Going back to whether or not Mr. Salem received an abuse of discretion at the trial court, it's our position that whether or not he received an abuse of discretion can be looked at the totality of the circumstances within the trial court and the demeanor that the court took against Mr. Salem throughout the case. And if we look at that, it's also including the April 25th, 2022 order from the trial court that deemed all of the property as marital without giving Mr. Salem the statutory protections under Revised Code 3105-171 that indicates that a party has the opportunity to have their separate property reviewed before what is deemed marital property.
But that was vacated.
That was vacated, Your Honor. But it goes to an overall theme in the trial court of the demeanor that Mr. Salem was under, and we believe that the court can review the entire record of the trial court, and that is also a relevant factor. Continuing the theme of arbitrary conduct from the trial court, directed to Mr. Salem was the consideration of attorney fees pursuant to Revised Code 3105.73 at a hearing on November 9th, 2022 that was only reserved for a discovery dispute and attorney fees in relation thereof. The order compelling discovery filed on November 22nd, 2022 only scheduled a hearing to discuss the Civil Rule 37 sanction. It was not a hearing to determine Revised Code attorney fees. It was a hearing to review Civil Rule attorney fees. Further, the appellee filed a motion on that day of the trial date on November 9th, 2022, requesting Revised Code attorney fees, to which Mr. Salem was not provided an opportunity to respond.
Was that the first time attorney fee had been requested pursuant to the Revised Code, the motion that morning?
It was not, Your Honor, but there was a brief filed and considered by the court on that day, and that's part of our objection.
Well, I think what Judge
when was the 310573 request made? If it was made before that time?
It was, Your Honor, in the hearing, but that goes back to the order that was issued on November 2nd, 2022. That order indicated that the hearing on November 9th, 2022 was for the issue.
But I understand, so you're saying the court didn't tell you that the court was going to proceed under the statutory proceeding as well.
Correct.
However, the court did, the App.No here did in fact notify you that they were seeking attorney fees under 310507.
Prior to November 9th, 2022, that is correct.
Did anyone object, or did counsel below object during the hearing about taking evidence regarding attorney's fees in excess of the amounts regarding the discovery dispute?
Yes, I believe I did, Your Honor. I indicated that we're here today just for the purposes of the Civil Rule 37 issue, and we're objecting to a consideration of attorney fees pursuant to the revised code. Now, assuming arguendo that Mr. Salem was given adequate notice that...
I'm sorry, counsel, I was a little confused.
Sure.
So the objection was made below?
Yes. So assuming arguendo that Mr. Salem was given adequate notice that revised code attorney fees were going to be addressed on November 9th, 2022, well, let's look at what happened. The attorney fee award was 10 times the amount of the attorney fees related to the discovery dispute and awarded under an abuse of discretion when Mr. Salem was arbitrarily denied introduction of the appellee's ability to pay her own attorney fees by denying introduction of evidence regarding assets and or income the appellee held in an Arab bank account. A similar situation occurred in the Wells case cited when the trial court arbitrarily excluded evidence in a child support determination pending the outcome of a divorce case where statutorily relevant factors were not considered by the trial court, one of them being the standard of living that the children would have continued to enjoy during the marriage. The trial court, in that case, denied the father and the mother the ability to address that issue in the trial court, and that issue was reversed.
Isn't that a little different though, because under the statute, it's not mandatory that the court considers, it's just a factor the court can consider.
That is a great question, Your Honor. I'm glad you brought that up. It is mandatory that the award has to be equitable, pursuant to 3105.73. Well, how do you determine equitability in a domestic relations case? You do that by reviewing the assets of the party, their income, and any debt. Mr. Salem was denied the ability to do that. How do we know the court acted arbitrarily regarding the exclusion of these bank records as exhibits and testimony thereof? It's simple. Mr. Salem was denied admission of appellee's Arab bank accounts, but the court admitted exhibits and testimony regarding appellee's Chase bank account.
So, counsel, I'm sorry, I'm still thinking of my question.
Sure.
So your answer to that question would be the statute doesn't require it, it's not mandatory, but you see it as an abuse of discretion that the court did not allow that information to come in.
That's correct. Because while it doesn't say that it's mandatory that the court has to consider their income and their assets, our position is how we determine the mandatory aspect of that statute, whether or not it's equitable, but for reviewing the income and the assets and the ability of each party to pay their own attorney fees. Without reviewing that consideration, you cannot determine the mandatory nature and language of that statute, whether or not it's equitable. To determine if the award was equitable in the trial court.
Counsel, you are at 90 seconds, so.
90 seconds ago. Okay. To determine whether or not the award was equitable, Mr. Salem indicated the relevance of introducing the Arab bank account records. And he indicated that the relevance was whether or not the appellee had an ability to pay her own attorney fees. The court responded, end quote, "I don't even understand that argument, and further, whether or not she's got money to have an attorney really doesn't matter to this court." This is cited in the December 1st, 2022 transcript, page 130 and page 133. Further, when after the court permitted Mr. Salem to inquire about appellee's Chase bank account, the court stated, "How long is this going to take?" December 1st, 2022 at page 130. And even though there was an interpreter, the trial court demanded that Mr. Salem ask Ms. Hammouda if she can even read the bank account records, and that Mr. Salem was not permitted to use the interpreter to translate questions about the bank account records when quoting the trial court, "We are not going to spend all this time for the interpreter to read through this entire exhibit for her." December 1st, 2022 transcript, page 139.
And counsel, you're gonna have to wrap up now because you're going into overtime.
This language was also indicated in the Wells case, and we think the Wells case is similar on this position. Thank you, Your Honors.
Thank you.
May it please the court, counsel, Tony Dalianis on behalf of the appellee. I want to remind the court that this is the third lawyer that appellant did have at the trial court level. There may be reasons why he may not be aware of certain procedural events that the court itself noted in its orders. The court is right that we did ask on November 18th of 2021, specifically under 3105.73 and Civil Rule 37. We again asked on 6/2 of 2022.
Dallas, was the notice for the hearing that is before us today, was that specifically for attorney fee and discovery dispute, or was that more generic as what the issue was going to be for that day?
Now to better answer your question, appellants only have appealed the court order granting the amount of the award. The court already granted the motion for sanctions, which they did not attach to the notice of appeal. They only brought it up in their reply brief after I brought it up that they never appealed the court granting the motion for sanctions. That hearing was a hearing for damages to determine the amount of attorney's fees. The
For
court
sanctions on the discovery dispute,
on attorney's fees.
on attorney fee for the discovery dispute, or just attorney fees in general, I guess?
It just said we have.
Mr. Flamenco was saying that it was limited to attorney's fees regarding the discovery issue.
The court's order specifically said it granted the motion to compel and for us to be prepared to argue attorney's fees.
Okay. And no more specific than that.
So when we went into the hearing, opposing counsel at that point in time was trying to introduce her discovery where he was trying to say she willfully withheld $600 of income that she had prior to the marriage in another country. But the court, Judge Cook had already known that fact and issued an order on that saying it wasn't a willful withholding. She listed on her interrogatories her failure to list on initial affidavit. She doesn't speak the language. She listed in your discovery responses. So we listed it. They had it. So they were trying to use that $600 as a reason as to why he doesn't have to comply with discovery. He doesn't have to list businesses that he has. He doesn't have to list apartment complexes that he sold with his brother. When we asked for this stuff, we were very specific in listing what was not properly given to us. In our motion to compel filed, we actually, on November 11th of 2022, we include the email dated February 9th of 2022 of their own counsel sent to me and to the client saying, these aren't right answers. Like listing your income and saying, I don't recall. Listing if you sold or bought any properties and say it's public record is not property discovery responses. Please respond. And she carbon copied me and him. We twice worked out a settlement agreement, and twice right before the trial, he withdrew it. And at the second trial, his lawyer then thereafter filed a motion saying his conduct was repugnant. So that's what we've had to deal with. So this is a homemaker that's had to defend this, where a court said, all right, you've already spent $34,000 in lawyer's fees, evading discovery, delaying this trial, delaying everything. This thing had hit, I think, the court's deadline to the Supreme Court. It was the third time we had said it. So the court warned everybody what the court was going to do. So they've only appealed the 37 part. They've not appealed the 3105 part. They've not appealed the where the court can under and did. Under 41A and 41B. And 41B specifically says that if a court dismisses an action, it can do so on the terms it feels so just and proper. They never even appealed that.
Well, counsel, I guess, I'm not sure what you mean by they didn't appeal it. They appealed the final order from the court.
Arguing only that under 37 that the court didn't comply. They didn't argue at all that the court failed to comply under 41 or the court failed to comply under Ohio's code. Those arguments were only brought up in the rebuttal brief after I pointed out in my brief that they have not attached any of those areas for appeal. Where the court held and granted the hearing on sanctions, there's no appellate record of that. Where the previous lawyer withdrew based on the conduct, there's no appellate record of that, which is their duty to file on the appeal. And it's his conduct that created all this. So he's coming before you, as we put, with unclean hands, begging you now to use your equitable power to find somehow that a court abuses discretion where it set a trial for 3 times and couldn't try a case because we don't know what he owns or what he's touched. We got 1 month's bank records. He testified he had 7 years worth. This homemaker has had to defend these are the docket entries. A total of 270 some. In a divorce case with a homemaker. In front of your honors, there were 4 appeals filed in January alone.
Counsel, let's just stay within the framework of.
What is the framework? It's to the reasonableness of the fees, which is what the trial court considered. The trial court in its order was specific. She's a homemaker. I've reviewed everything. I've reviewed the facts. We have affidavits on file. You guys listed what you have on the affidavit, so what she had before her. And they presented no evidence in contrast to the reasonableness of the fees. Nothing. The court even asked them, are you going to put anything on? No. They were hoping that that was the hearing on whether or not to grant 37. The court had already granted 37. That was a hearing on the amount for fees. The court also held a hearing and issued an order in the final order based on our motion filed as early as 2021, where they're saying that wasn't time enough. Judge Cook issued an order of a discovery deadline.
Well, we're appealing here, and the fees were ordered on Judge Cook's 12/16/22 entry, is that correct?
The entry that was attached, Your Honor, is
It's after the hearing on November 2nd?
January 12th.
Or November 9th? Okay.
And none of the other orders or hearings.
I guess I'm reading the order that sets the attorney's fees. Is it clear that the judge below was considering 3107.53? It seemed to be much more focused on the violation of the civil rules.
Whether the court specifically provided notice on that number, I don't know that the court provided notice for that.
With the court's order, did it go through an analysis, in a separate analysis under civil rule, or excuse me, under the statute to say I'm awarding these under the statute.
It did in the final
I've
order.
looked at all the equitable factors and decided it's equitable.
It did. In fact, it went through and it said, even though I don't have to, I did weigh the case terminating versus the lesser sanctions, but plaintiff's failure to act and plaintiff's conduct evidence of bad faith, which significantly prejudice defendant as set forth
But
above.
that seems to go forward for the decision to dismiss the case as opposed to some other, taking some other action or some other sanction. I'm looking at the order before us, it's unclear to me exactly how Judge Cook was discussing this equitable issue of attorney's fees. That's where I'm kind of lost in the order. I understand you made the motion, does the order clearly say, here's how I find under the revised code section why I'm ordering $37,000 in attorney's fees?
She did break down that there was evidence presented as to the reasonableness of the fees and the amount of the fees. She did also attach there too that she's doing pursuant to Civil Rule 37, and that proper notice was found pursuant to Civil Rule 41A2 and 41B1, because she did provide that in her proposed order. She said if discovery isn't provided, then I'm going to dismiss the case. One second, let me make sure that I can address all the points. So regarding the 11/16 or the November 2021 filing, where it was 2 days before the discovery deadline, Judge Cook had issued an order that we had to file all motions to compel prior to that day. We filed it on the day that I got my discovery from First Counsel. I emailed them of all the responsive pleadings that were missing, and then I hand-delivered a copy because it had Social Security, it had all kinds of private information, not only to the court, but to counsel's office. That was also included as the specific items that were missing in our second filed motion again, which incorporated the email where we specifically listed of each and every item that we didn't have. So it's our position that the court did have the power, the court did act properly, they failed to appeal the proper parts of which they're litigating here today. The court did not abuse its discretion anyway, there's no...
Did the court make a ruling on the motion to compel within 1 day of them being filed as counsel suggests?
The most recent one, the 11/1/2022, the motion to compel was filed because there was hearing on the record where the court said if we didn't receive discovery by a certain time, that we should then file our motion, which we then did and complied with the court, which is why the court then issued the compel order to try and get discovery to us prior to the third trial date that the court had set, at the request of appellant in withdrawing his 2 previous agreements and the actions herein. The email included on 2/9/2022 is from appellant's own counsel, agreeing to forward that information. And since the beginning, we've asked for this information. I can't litigate the case properly to defend a homemaker that makes $19,000 a year imputed. And they're arguing that the $600 that she listed after the initial filing, without an interpreter there, is what she testified to as the affidavit, is a reason as to why the court now should not order an equalization of what attorney's fees were already ordered on the other side. The court kind of looks at this thing as a waste of everybody's time of 270 some docket entries and now the 4th appeal. Thank you.
Thank you very much, counsel. Thank you, no, your time is
Oh, it's all gone.
actually
Okay.
expired, yeah.
Thank you. Sorry about that.
Thank you both for your presentations. The court will take the issue under advisement and issue a decision in due course. The clerk of courts will mail a copy of that decision to you on the day that it is released, and it will also be posted on the Ohio Supreme Court website. Thank you very much again.
Thank you.